Welcome to the Arbitration World podcast, in which we focus on significant developments and issues impacting international arbitration. We hope you enjoy this discussion. Please do get in touch with us if you have any questions about this week's episode or any areas you would like us to cover in a future podcast in this series.
Well, hello everyone, and welcome to this podcast in the K&L Gates Arbitration World podcast series. My name is Peter Morton, and I'm a partner at K&L Gates here in London. I'm one of the practice group coordinators of the firm's International Arbitration Group and a member of the firm's Aviation Group. In a previous podcast, we reported on the formation of the Hague Court of Arbitration for Aviation, the HCAA, which offers both arbitration and mediation services to the aviation industry. In that first podcast, we spoke with Paul Jebley. Paul is founder and chair of the HCAA, and we spoke with Paul about the arbitration of aviation disputes, including under the HCAA rules. Today, we're going to be looking at mediation and the potential benefits that mediation can bring, specifically in the context of aviation disputes, and the key features of the mediation rules of the HCAA. I'm delighted to be joined by two distinguished guests to cover these topics. Firstly, David Bartlett. David's career in aviation law started in private practice in 1988, following which he held senior in-house legal roles with GE Capital Aviation Services, GECAS, at the time one of the world's largest aircraft lessors, including as head of dispute resolution globally in litigation, arbitration and mediation, and became managing director and general counsel of PK Air Finance. David teaches aircraft finance and procurement for the advanced LLM in air and space law at the International Institute of Air and Space Law, Leiden University. David trained as a mediator with both CEDA and the Society of Mediators and is a member of the advisory board of the HCAA. Welcome, David.
Thank you for having me.
Secondly, Paul Ng. Paul heads the aviation practice of Rajah Tann in Singapore. Paul is a professor of law at Queen Mary University of London and adjunct professor at the National University of Singapore. Paul is a member of the prestigious legal advisory panel to the Aviation Working Group, the AWG, and specifically chair of the Southeast Asia Group. Paul is co-chair of the HCAA's Mediation Standing Committee and a key member of the team behind the authorship of the HCAA Mediation Rules. Welcome, Paul.
Thank you.
Well, before we get started, I'm just required to note that this podcast is limited in scope as appropriate for a general audience and under applicable time constraints. It's not offered as legal advice, which should only be obtained from properly licensed legal professionals on the basis of the specific facts of a given case. All speakers appear in their personal capacities, and any opinions or views offered are those of the relevant speaker alone and do not necessarily reflect the opinions or views of K&L Gates LLP or any other entity or individual. Okay, so with that introduction, David, do you want to kick things off just by giving us a brief recap of the formation purpose of the HCAA and this dual offering of arbitration and mediation services that I touched on in the introduction?
Sure, Peter, thank you. I think if you listen to the podcast you did with Paul Jebley, he gives a very good background as to why the HCAA came into existence. So I won't go into that in any huge detail. The main sort of ethos behind it is to promote alternative dispute resolution in aviation. ADR has been used, whether it's arbitration or mediation, for quite some time in aviation, but it's not uppermost in the mind generally. And there weren't specific clauses, for example, to refer disputes to arbitration in aviation disputes. So I think sort of recommended clauses and practices were thought to be lacking, and the HCAA addresses that, both in terms of aviation mediation and arbitration. So that, I think, is the sort of background to this. You have a specialist body involved to assist the industry when they're dealing with alternative dispute resolution.
Great. And just stepping back, what do you consider the key features and potential benefits of mediation to be, and importantly, how specifically those potential benefits can come to apply to disputes in the aviation sector?
Sure. I mean, I think the usual benefits of mediation apply, and if anything, apply more so in some of the aviation dispute. The biggest one is the parties have autonomy and control of the outcome. Ultimately, the process doesn't result in an outcome imposed by a judge or an arbitrator. The parties have the freedom to agree a settlement that includes things that an arbitrator or judge couldn't order. And I think one of the strengths of mediation is that nothing is agreed until everything is agreed. So you can have much more creative solutions. And I think there's no doubt that in an industry like aviation, which is relatively small when you think about the players involved, whether that's manufacturers or ground handling agents or insurers, and if you think about it, it's quite a limited universe of people. And you really do need to preserve and build on those relationships rather than enter into a destruction process that litigation tends to be very hard, I think.
Yeah, go ahead, Paul.
Well, actually mediation as a dispute resolution technique almost predates any other form of dispute resolution, because it dates back to 1800 BC, and the Greeks and Romans used it. And totally agree with David that mediation has benefits over litigation, which litigation is expensive, time-consuming, win-lose, and public. While mediation is none of these things. I mean, it can be very cost-effective, quick, and does not destroy the commercial relationships that the results of litigation that creates, and it is private, confidential, and as David says, there's a lot of ability for the parties to exercise self-determination and negotiate a settlement, and that hence the ability to preserve commercial relationships.
I think the other thing, again from my experience sort of in-house, I think people underestimate the internal cost and distraction for senior management if they get involved in a dispute that drags for a long time. So an efficient use of a day in mediation is going to save, or potentially has massive cost savings, but also the distraction for senior management. Paul, I mean, if you've got to sort of line senior management up to come and talk in court or discussion with auditors, and it takes up time at board meetings, all that sort of stuff has a cost when really the business wants to be getting on with the business, not sort of dealing with a dispute that should have been dealt with months earlier.
Yeah. David or Paul, I don't know if you want to touch on the importance of swift, efficient resolution disputes in the aviation sector and the sort of the costs of time. Any particular thoughts on that aspect?
The other beauty, I guess, with mediation is you can actually get the process underway very, very quickly. Right? I mean, if you need a mediation for the HCAA, you can get you a mediator, and you could be in with that mediator within a week. Right? If you're kicking off arbitration or litigation, you're not going to get a hearing sort of really advance the thing on for months. And if you've got a lease dispute about a delivery condition or a sale and purchase agreement where does the aircraft meet the specifications or whatever, you don't want to wait 6 months to sort of get a hearing. You want that dealt with promptly, and if a resolution can be agreed, mediation to me is the obvious answer there.
Exactly. So mediation is procedure light. And if you look at the HCAA approach and our mediation rules, it can commence just upon the confirmation of the parties' willingness to engage in mediation by filing a request of mediation to the Secretariat. That starts it. Have a complicated, long process where people have to seek courts have to seek jurisdiction, procedure-intensive, time-consuming, costly process just to even start the dispute resolution.
Yeah, perhaps picking that up with you, Paul, do you want to give listeners sort of flavour of some of the key aspects of the HCAA mediation rules? Are there any particular distinctive features of the rules and procedures that users can expect?
Sure. When the HCAA was set up, we had an original set of rules which was quite generic. And back in 2023, towards the end, 24, we wanted to launch the mediation. The HCAA mediation was the result of a long consultation process with experts, academics, working mediators, aviation specialists, technical people to customize the rules for this industry, because there wasn't none that existed before. There were those that existed for intellectual property, for shipping. None existed for aviation. Now, when we had to make that decision, it was a tough one, because it was, do we make it generic, so they can cover most situations, or very specific? And we felt that because the disputes that could arise in aviation was so varied, we still needed to keep the rules quite generic so that it has wide applicability. Despite that, the HCAA rules are some of the most modern, advanced rules that exist right now. We consulted with the existing mediation rules for most of the leading mediation centers and tried to extract the best from them. And we consulted with professors in Cambridge, Oxford, and elsewhere, both civil and common law countries, all part of the working committee which I co-headed to write these new rules. So maybe I just mentioned 3 unique features. The first is not particularly a unique feature, but the fact that the mediation rules apply to a mediator pool or expert pool that is appreciates the technical, commercial, and regulatory dynamics of the aviation industry, which is a unique industry, highly regulated, highly technical. So you are not getting, when you choose a mediator from the pool, you are not choosing someone who is someone who doesn't have experience in this sector. So it doesn't require the level of run-up time and that you would need for someone who's not familiar with the industry. That's the first. So we have a pool of mediators that have been selected carefully by the HCAA Executive Board and the NAI, which is the Netherlands Arbitration Institute, one of the oldest arbitration mediation institutes in the world. And they are all experts and pre-approved by this group. The second is that the rules have both hybrid and virtual and live mediations. So it provides for choice for people to decide what method they want to conduct the mediation through. It also has quite forward-looking approach to technology and has an AI usage declaration for parties that use AI. They have to deliver a declaration of use, and they're encouraged to notify the other party as to the AI tools that are being used and the purposes for which they are used. This is essentially to make sure that parties acknowledge that data protection laws are safeguarded, and places responsibility of the declaring party to verify that AI-generated outputs have been reviewed by them, and that it discourages uncritical reliance on them. I mean, no other mediation rules have this. And lastly, it does encourage the diversity, the benefits, and encourages mediators to be mindful of the benefits of diversity and also environmental impact when conducting the mediations. For instance, all mediation communications under the HCAA rule are to be conducted by email unless directed by the Secretariat. In one of the approaches to being a more ESG approach to mediation is just some of the advances that we have that you would not find in other mediation rules.
Great, thanks. And perhaps sticking with you, first of all, Paul, for parties that may be interested in providing for or proceeding with a mediation under HCAA rules, is there any requirement as to how or by what means HCAA mediation might be agreed, just for our listeners to be aware of?
I think that on this aspect, it's the typical approach of either putting it into your contracts or you can agree it afterwards as well to use the HCAA rules. There are countries that require mediation before litigation. So we are hoping that more courts in countries will adopt this. Many of the Asian countries have already adopted this approach, but typically we encourage our members to incorporate them. We have a standard model mediation clause to be put into their contracts.
Understood. So with that context, so David, turning it back to you, from where you sit and what you know of the HCAA and the rules of mediation, from your perspective, why should parties operating in the aviation sector opt for mediation under the HCAA rules, perhaps, as contrasted with another general mediation services provider or an independently arranged mediation? What do you see as the key benefits?
Sure. I mean, I think traditionally mediators are trained to be process experts, right? They're trained in the process. But they're not content experts in any particular industry, and aviation is specialized. So when you're dealing with complex regulatory frameworks, the technical language, obviously, of leases, and just general vernacular, AOG, what does that mean? What is a wet lease? You've got operational realities of how much money it costs if an aircraft is grounded. You've got the whole thing of the just culture, the sort of safety issues behind the industry. You've got cross-jurisdictional risks if you're dealing with litigation as the alternative. And so I think one of the big things is that you don't want to be explaining, as an aviation executive, you don't want to be explaining the first hour or so to a mediator as to what a wet lease is. And it's the same sort of points that were made to having a specialist arbitration tribunal as opposed to the sort of more general practitioner. If you want to go and see a consultant, if you've got something seriously wrong, it is the consultant you want to go and see, not your general practitioner. So I think there's that general degree of specialism. But the bigger thing for me, I think, is that one of the skills that mediators are taught to develop is that of active listening. And I think one of the things that the internal sort of industry expertise gives you is the ability to listen and hear what is not being said. All right, the points that you would expect to be raised, but perhaps are not being dealt with because they may be sensitive. And I think that gives the mediator with industry background a better way of understanding and perhaps reframing the issues in the way that mediators are generally being taught. So I think that it's that sort of degree of specialism that the HCAA mediation process will give you that I don't think generally you'll find more widely. But that is not to say, of course, that there aren't some very good mediators around who aren't aviation specialists.
Just turning to the important question of costs. So listeners may be thinking, well, isn't this all very expensive? Would one of you just like to cover what are the categories of costs that people ought to have in mind when considering proceeding with a mediation under HCAA rules? How are those costs calculated? What are they based upon, and so on?
Well, I can say what the rules say, and they are limited actually to two main categories. One is the administration of the mediation, which at the moment the administrator is appointed by the NAI, and the costs are scaled to the size of the dispute, the financial dispute, and there's a table at the end of the mediation rules. That table will be escalated from these rates were set in 2023. That's the first set of costs, which is not substantial. So that's the administration, and then mediator fees, and these are also scaled according to the size of the financial interests of the case.
Would it help if I give some examples? Because as Paul says, these are. I mean, if you've got a dispute, let's say you've got a $20 million or €20 million dispute, the arbitration administrative cost is the sort of base number is €9,000. So I mean that's very modest compared to what you pay for a court fee, for example. And the arbitrator's fees, they're done on an hourly rate, or they can be a daily rate. But at an hourly basis for that sort of dispute, you're probably paying something in the region of €400 an hour to the mediator. So you compare that to what you'd be paying your solicitor or your barrister. That actually works out, I think, at a very cheap rate for the day. All things, it's €400 an hour is obviously not cheap, but on the other hand, it's cheaper than that you're probably paying that'll give you an idea of the cost. And then you've obviously got to add on top of that your own legal costs for the day and the preparation. But the chances are, if you're going to go through litigation or arbitration, you're going to be spending that anyway in terms of case preparation and briefing your lawyers. So yes, there's obviously a cost of having a typical mediation takes a day. So you have an extra day to the process, but actually there's quite a lot of overlap.
Okay, and finally, I understand that in February 2024, at the Singapore Air Show, the HCAA and the Singapore International Mediation Centre, the SIMC, signed a memorandum of understanding. Paul, do you want to tell us about that? What was the background and significance to your mind of that development?
Well, I think for your listeners, just so that they know that this is against the backdrop of something called the Singapore Convention on Mediation, and that convention establishes a uniform international framework for recognition and enforcement of what they call INSA, which is the International Mediated Settlement Agreements. Now, this was a important convention sponsored by the Singapore government and championed by the SIMC, the Singapore International Mediation Centre, which aims to, replicate one of the most successful private international law treaties, which is the New York Convention, which recognizes and enforces arbitration awards. So they want to replicate what the success of the arbitration process with mediation. And SIMC is one of the most reputable mediation centers in the world, very popular in Asia. And we thought for purposes of having a location where there's bricks and mortar for dispute, for parties to meet, to do live mediation if they want, and also to leverage off the sort of considerable resources of SIMC to help. We help them for our industry, and they help us to reach out further into the world of alternative dispute resolution. And our collaboration also includes training and certification, which we are in the process of finalizing. And so we think it's a synergistic collaboration, and so far it's been going well. Yes.
Yeah, because I think under the HCAA rules, there's what, to my eye, seems a fairly novel provision that if it's agreed by all signatories to the settlement agreement may be issued in the form of an arbitral consent award. That's Article 13, and presuming that ties in with what you've just described.
That's right. So we not only the settlement agreement not only takes the benefit of the Singapore Convention, or you can get it enforced and recognized in countries, member states of the Singapore Convention, but if it's then converted through a process to become a consent order, it can also benefit from the New York Convention. And the fact that the HCAA has both arbitration and mediation capability, we think that it's a win-win situation for anyone that uses the HCAA approach to trying to resolve disputes. Firstly, through mediation, finding a settlement agreement, and then converting it into an arbitral award.
I think we'll wrap it up there. It just leaves me to thank Paul and David for joining us today for what was a very interesting and insightful discussion. Thanks very much to both of you.
Thank you.
Thank you, Peter.
Thank you for listening to this episode of Arbitration World Podcast. To listen to past episodes and receive notices for new episodes, subscribe by searching Hub Talks, that's HUB Talks, in your favorite podcast app. We hope you will join us next time for further discussions on hot topics and significant developments in international arbitration from around the globe.